Okay, that would all be part of the trial in December if it gets there. That's what Bob Pockrass tweeted. Okay, so NASCAR is asking for an injunction eliminating guaranteed starting spots for the charter teams. So basically saying, like, if you're going to sue us, why do you have a guaranteed spot? But again, that would not impact this 2025 season. This is all moving forward 2026, and we'll see what happens if there is actually a trial coming up in December.
The NASCAR world has been rocked by an explosive development in the ongoing legal battle with Michael Jordan's 23XI racing team and Front Row Motorsports. On Wednesday, NASCAR filed a countersuit against these teams, accusing them of forming an illegal cartel, a move that many industry insiders see as a desperate attempt to regain control of a situation that has rapidly spiraled out of their hands. The countersuit represents a significant escalation in what has become the most contentious legal fight in recent NASCAR history. This legal drama threatens the very foundation of NASCAR's business model and could permanently alter the landscape of America's premier stock car racing series. NASCAR's countersuit makes a bold claim that 23XI Racing and Front Row Motorsports, along with Jordan's longtime business manager Curtis Polk, willfully violated the antitrust laws by orchestrating anti-competitive collective conduct in connection with the terms of the 2025 charter agreements. The 30-page filing specifically targets Polk as the mastermind behind what NASCAR characterizes as a scheme to pressure the racing body into accepting more favorable terms. The lawsuit alleges that Polk led efforts including engaging in media campaigns, interfering with NASCAR's broadcast agreement negotiations, threatening boycotts of NASCAR events, and engaging in a group boycott of a NASCAR team owner council meeting. NASCAR attorney Christopher Yates didn't mince words when discussing Polk's role. Curtis Polk basically orchestrated and threatened a boycott of one of the qualifying races for a major event, and others did not go along with him. He got other teams to boycott a meeting that was required by the charter. Yates went further in his criticism of Polk. "I don't think Mr. Polk really understands the sport. I think he came into it and his view is it should be much more like the NBA or other league sports, but it's not. No motorsport is like that. He's done a lot of things that might work in the NBA or might be okay in the NBA, but just are not appropriate in NASCAR." This countersuit follows an October 2024 antitrust lawsuit filed by 23XI Racing and Front Row Motorsports against NASCAR and CEO Jim France. That initial lawsuit accused NASCAR and the France family of being monopolistic bullies who use anti-competitive and exclusionary practices to enrich themselves at the expense of the premier stock car racing teams. The teams specifically allege that NASCAR has unlawfully maintained its monopoly position for offering a top-tier stock car racing series in the United States in violation of the Sherman Antitrust Act. This initial legal action came after contentious negotiations over NASCAR's charter system, the equivalent of franchises in other sports that guarantee teams a starting position in races and certain financial benefits. The dispute centers on NASCAR's charter system, first introduced in 2016. Charters guarantee teams a starting position in all 36 Cup Series races, financial guarantees and revenue sharing, other monetary incentives. The previous charter agreement expired at the end of 2024. Teams and NASCAR had been locked in tense negotiations for over 2 years regarding the extension terms. What began as a $2 million investment when charters were introduced has exploded in value. By 2023, one charter sold for an astonishing $40 million. Last year, 23XI, and Front Row reportedly paid between $20 to $25 million each for single charters from Stewart-Haas Racing. The situation reached a breaking point in September 2024. NASCAR presented teams with what was effectively a take-it-or-leave-it offer just 48 hours before the start of the Cup Series playoffs. This offer included increasing teams' share to nearly 50% of NASCAR's record $1.1 billion per year television deal that began in 2025 and runs through 2031. According to court documents, NASCAR allegedly told teams that if they didn't sign by a midnight deadline, the charter system would be dismantled at the end of the year. Under this pressure, 13 of 15 teams signed the extension. Only 23XI Racing and Front Row Motorsports refused. Hendrick Motorsports owner Rick Hendrick admitted to signing out of exhaustion. Multiple teams told the Associated Press that the contract document was filled with grammatical errors and was far from being ready for signing. The teams had sought several key concessions that NASCAR refused to grant permanent charters. NASCAR can currently claw back charters from underperforming teams, a larger share of television and media revenue, formal governance roles, profit participation when team or driver likenesses are used. In December 2024, 2311 and Front Row scored an important early victory. A federal judge granted a preliminary injunction, allowing them to compete as charter teams for the 2025 season, while the legal proceedings continue. This was a significant blow to NASCAR, which is now appealing this decision before the U.S. Court of Appeals. The hearing is expected to take place in mid-May. NASCAR isn't just making accusations, they're seeking serious penalties against the teams. The countersuit asks for triple damages, elimination of guaranteed starting positions for 2311 and Front Row if they continue litigation. Return of the 4 combined charters held by 2311 and Front Row to NASCAR. NASCAR attorney Chris Yates made the stakes clear. If they prevail, the charter system likely goes away. The teams quickly responded to NASCAR's countersuit through their attorney Jeffrey Kessler, who dismissed the legal action as a meritless distraction and a desperate attempt to shift attention away from its own unlawful, monopolistic actions. Kessler's statement continued. NASCAR agreed to the joint negotiations that they now attack. When those joint negotiations failed, they used individual negotiations to impose their charter terms, which most of the teams decided they had no choice but to accept. He framed the team's lawsuit as part of a larger historical pattern. My client's lawsuit has always been about transforming NASCAR into a more competitive and fair sport for the benefit of drivers, fans, sponsors, and teams because of their love of the sport. Every major sport goes through a transition to competition when antitrust claims are asserted, and that moment has come for NASCAR. The statement concluded with confidence. Today's baseless filing changes nothing. We are confident in the strength of our case and look forward to presenting it at trial. NASCAR's countersuit singles out Curtis Polk as the central figure in what it characterizes as anti-competitive behavior. According to the filing, Polk orchestrated and threatened a boycott of qualifying races, specifically the 2024 pair of 150-mile duels that set the field for the Daytona 500, got teams to boycott a meeting required by the charter, coordinated negative media campaigns against NASCAR, interfered with NASCAR's broadcast agreement negotiations, threatened other teams not to break ranks during negotiations, failed to accurately convey NASCAR's position to other teams. The filing states, Polk's individual role was at the very center of the plot to use collusive behavior to extract more favorable commercial terms from NASCAR in the charter negotiations. In one of the more surprising allegations, NASCAR claims that members of the Race Team Alliance actively deterred potential new ownership groups from entering the sport by purchasing charters. The lawsuit specifically cites Xfinity Series team owner Dale Earnhardt Jr. as someone who was dissuaded by the RTA. According to the filing, Earnhardt explained on his podcast that this charter that I want to buy is a losing proposition. It's broken. That I don't want to buy this charter now because it's not a successful business. NASCAR alleges the RTA did this with the intent to consolidate their own positions by purchasing additional charters themselves. Despite NASCAR attorney Chris Yates claiming he didn't know what the teams wanted, the court filings tell a different story. Paragraph 53 in NASCAR's filing states that, in June 2022, the team negotiation committee, led by Polk, presented initial demands including $720 million annual payment to teams, 33% of all new revenue sources that include team rights, 33% of media increases, permanent charters, a change of control provision, additional approval rights on issues such as race schedule, electrification, and new industry initiatives. Paragraph 69 further states that the charter teams demanded NASCAR pay at least 42.7% of all media revenues to teams during the term of the agreement. This directly contradicts Yates's claim that, I don't know what they think is fair. They have never explained that. I have no idea what they think the appropriate split should be. 2311 co-owner Denny Hamlin, who also drives for Joe Gibbs Racing, offered a pointed response to the countersuit on social media. When NASCAR attorney Chris Yates claimed the teams never made their demands clear, Hamlin replied on X, "You should have a fact-checker in the room at all times." Despite the legal tension, Hamlin emphasized his continued commitment to the sport, writing, "Come see me actively promoting and growing our sport this Saturday." This was in response to an announcement that he would be making several appearances during the race weekend in Phoenix. Fans rallied behind Hamlin with one writing, "Elamau, dude, regardless as to how people feel about you on the track," which I happen to love, but you are the voice this sport has been missing for years. Thank you for never selling out. We appreciate you, Denny Hamlin, more than you get credit for. Another added, "Thank you for trying to save the sport.